In doing plaintiff's work, I've seen, at least in the year I've been doing it, that I've been able to be way more creative. I've been able to really, I hate the term thinking outside the box, but, think outside the box on how I approach cases, really kind of utilize some of the lessons that have been taught and all these books, a lot of really, really good lawyers have put out there. I poo-pooed a lot of this when I was a defense lawyer. I used to call, the reptilian, theory. I said, that's a crutch for the mediocre trial lawyer is what I used to call it. And then, you start really looking into the effectiveness of some of these techniques from a David Ball, et cetera. And it's like, well, objectively speaking, this stuff's working. And it's, you look around now with the nuclear verdicts, as the insurance defense industry likes to call them. You look around.
I like to call them fair verdicts, but yeah.
Sure. But there's a reason for the uptick in these verdicts. And it's this almost a common approach to litigating these cases, which really is almost indefensible. You can't defend the way really good plaintiffs lawyers are prosecuting these cases. It's almost impossible.
What is it you can't defend?
Well, with these cases that you see where, UPS is the exception to the rule with respect to their safety program. UPS actually has a safety program, and they put millions of dollars, if not tens of millions of dollars a year into it. That's, as you well know, is the exception to the rule. If everybody did what UPS does, not to say UPS doesn't make mistakes and they don't have drivers that make mistakes, they do. And they've got 120,000 power units on the road at any given time. You're going to have somebody that makes a mistake just, by virtue of statistics, right? But it's typically not a lack of UPS trying to train that driver to not do what he does. In these other cases you see with these other companies, these fly-by-night companies, or even some of the bigger companies that just don't really care to train. They don't want to put their money there because what is that? That's money that could be going in their own pockets.
Right.
So instead of putting the money into training, they just rely on this idea that, well, we get a CDL trained driver. That's all we need to do. He's trained, to drive a tractor trailer, and I'm going to put him on the road. We're good to go. And those cases, as you've seen, you're attacking really the company as opposed to the driver. You're almost making the driver sympathetic to a jury.
Absolutely.
And when you do that, it's a very, very, very difficult bell to unring when it becomes about the company as opposed to the person sitting in the driver's seat. As a defense lawyer, I always like to say, hey, this is all about, I would tell courts this is all about the 5 seconds. This isn't,
right.
This isn't about the 3 months prior. This is about the 5 seconds in this accident. If you can make it about the 3 months prior or the 3 years prior and really delve into what hasn't been done here to protect the motoring public, you're going to be in good shape as a plaintiff's lawyer.